Hi everyone, I am Ayushi Jain from School of Law Modi University working as a legal intern in LEXIS and company. Today in this video I am describing about state cannot control right to consume alcohol within one's house. The state cannot control right to consume alcohol within one house. The petitioner argues in the Gujarat High Court against the liquor prohibition. The Gujarat High Court is hearing a batch of PIRs challenging prohibition on manufacturing, sale and consumption of liquor in the state wide of Gujarat Prohibition Act 1949 on the ground of manifest arbitration and violation of right to privacy. Responding the primary objection raised by the state, the senior advocate Mir Thokre today argued that the challenge of the legislation before the Supreme Court was not only limited extent of medicinal and toilet preparation. The proceeding were confined to prohibiting the use of medicinal and toilet preparation. The challenge was not absolute. The challenge to another party to provision was not kept aside, he submitted. Advocate General Kamal Tiwari on Monday argued that the petitioner was not maintainable as such much as issue called in issue question as already been settled by the Supreme Court in the state of Bombay and another versus FN Barsala, where validity of the Act 1949 was upheld. He argued that emergence of the new ground for challenge cannot be based for the disputing the syndication of the Supreme Court judgment. Thakure has argued that the question of validity of prohibiting consumption of alcohol not decided by the Supreme Court, and in this context the Gujarat High Court is competent to adjudicate. What is the basic of differentiating between people? My challenging is on the ground of privacy. If I could consume liquor in the pretend of my home, the right you cannot control. If I misuse it, go out and misbehave, then certainly you can catch hold on me, he said. The advocate Mir Joshi linked the right to privacy with the citizens' right to eat and drink as per their choice and remarked, what to stop the state from coming into homes and saying, no non-veg from tomorrow, he asked. Thokre stated that several provisions that the petitioner has challenged were not current issue before the Supreme Court. Some provision whose validity was decided by the Supreme Court in 1951 has maternally abandoned. Since a certain provision has been added by the subsequent amendments, the Supreme Court considered Section 14 and 13 prohibition of sale and manufacture of liquor to the extent of medicinal and toiletry preparation only. Section of 24(1)(a)(b) prohibition on the entry in the state in intoxicated state was not existent then. Section 43 regulation of use consumption of foreign liquor by permitted holders was not under challenging before the Supreme Court, Thakre pointed out. He asked, judgment of the Supreme Court was not have effect that the petition is maintainable, independent or lordship can decide upon this section. They are undergone material changes. He stated that the judgment cited by the AG pertain to case where same section was challenged again. It has been same section challenging on a different grounds. He is only a part of the section was challenged, he submitted. Adding to this, Advocate Saurabh Sopre said liquor consumption was not controversial before Supreme Court. So obviously, what is not in dispute before it cannot be accepted to be adjudicated by it. Advocate Diwan Parikh submitted that there was a distinction between principle of precedent and principle of res judicata. He stated that the judgment of Supreme Court, which was decided on competence of the legislature, is limited and it is still open to another party to challenge the violation of the fundamental right. If the Supreme Court has taken a view that the legislation have the power under the particular entry for the purpose of enacting a law, then in its they should descend is for a purpose of the entry in question. The power of legislation is decide. Tomorrow, if I contended that of the same legislation, I come and say that I am not arguing the context of the legislation competence. I will argue on the basis of Article 14. The principal precedents do not say that you cannot adjudicate, Parekh said. He also added, in contents of constitution, the principle of prudence do not have adhered to with the amount of strictness. If the court at the point to time think the law as Jain required to be re-look, that may be done. Advocate Mihir Joshi argued that challenging the principle on the basis of right to privacy, which give a voice by the Supreme Court in 2017 in Puttoswamy judgment, this could not be felon for the consideration of 60-year backs. Argument of Mr. Tiwari that new ground cannot be taken is new ground that is available cannot be taken. New ground where new fundamental right has received expiation of this by the Supreme Court, he said. He also added, a law once held valid can be held unconstitutional with the passage of time. Constitution cannot be static, otherwise it become dead letter. Joshi further said that the objection raised by the state cannot even a call of preliminary objection, and the same decision were hearing merit of the case. However, the bench said that it was here the council at the length and it will first decide whether preliminary objectives are sustained or not before proceeding any further. The matter is kept for hearing counter by tomorrow, that is 24 June 2021. The case title of this is Rajiv Piyush Patel versus State of Gujarat. Thank you.